The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone, and welcome to the Board of Pharmacy's webinar today. I'm Tom Glinsky, Chief Inspector, and my guest today is Kimberly Grinston, our Executive Director. She's going to give us an update on the 2016 legislative session. Before we get started, I'll just go through some of the basic information about our webinar today. All participants are in listen-only mode. If you have any trouble connecting to the audio over a computer, there is dial-up instructions in the GoToWebinar toolbar on your screen. We will be giving 1 hour of CE for this program. You must be officially signed up and logged in via your computer to get credit. If you're just listening via phone or in a room listening to someone else's computer, you will not get credit. You must be signed into the GoToWebinar program to get credit. At the end of the program, we'll have a survey that pops up, and then we'll give you more instructions about that at the end of the webinar. Our CE is not reported to the CPE monitor, so you need to save the certificate that we'll mail you for your CE credit. Handouts of the webinar are posted on the board's homepage. Under the registration section, there's now a link to the handouts for this webinar. We had a previous webinar earlier today, so both links are on there for the handouts, so make sure you click the right link. We make a recording of this webinar and post it on our website, and you can find that under the Publication and Resources link on our homepage. There is no credit, CE credit, for watching a recording of a webinar. We will, if time permitting, take questions at the end of the program. If you'd like to submit us a question during the program, go to your GoToWebinar toolbar and type in the question and hit send, and we'll see how many we can answer at the end of the program. So I'm now going to turn it over to Kim Grinston, our Executive Director.
Thank you, Tom, and good afternoon to everyone joining us on the webinar. As always, thank you for joining the board. This is part of the series of webinars. It is part of the board's initiative to reach out to our licensees to increase education. And it is the board's opinion that as you increase education, we increase compliance. Tom mentioned this earlier, but the board's webinars recordings are posted online. For those of you who are joining us for the second time today, we did a previous sterile compounding webinar earlier this morning. You will hear some of the same things again, but recordings are posted online. We would invite anyone, if you have staff, if you have coworkers who are unable to attend, or if you'd like additional information, we invite you to go to the website and watch a replay. CE is not available for the replay, but you will be able to find some information. So let's talk about our objectives today. Our objectives today are to discuss 2016 legislative outcomes. We're going to talk about what passed during this past legislative session and what's going to be effective on Sunday of this week. If we have time, we'll also look at some of the 2015 inspection violations, and we'll provide some information on that, and we'll also try to answer any questions that you may have. Before I get started, I have to, I'm an attorney, there's always a disclaimer. I want to remind you that this webinar is just a summary of key legislation that passed last year. It doesn't include everything that may impact licensees. There are other pharmacy-related pieces of legislation that may not impact what we do as a board from the regulatory standpoint. I would encourage anyone who's interested to go to the Missouri General Assembly's website. They do have a list of legislation that did pass. This presentation is being provided for informational purposes only. I am not providing legal advice. Of course, you should talk to your legal counsel if you have specific legal questions, nor are we going to give anything that should be construed as a binding rule or an opinion. In the event of a conflict between anything I say today and statutory language, of course statutory language would control. And again, we invite you to look at the pieces of legislation that we'll be discussing today in their entirety to make sure you are in compliance. Again, our job today, what we'd like to do is just give you a bird's eye view of what passed some of the key compliance questions you may have and or requirements, and then again have you look at the website if you have additional information. Before I begin, I do want to note that the board on yesterday released our August newsletter, and we did a special edition for August. We included a summary of pretty much everything that I will discuss today of the 2016 legislation. So if you have additional questions, you need sites, you need additional information, go to the board's website and look at the August newsletter. If you're not signed up for the board's newsletter and or e-alerts, you can do that while you're on the website as well. But again, this information is in writing, and you can go back and look at it then. Okay, so let's talk about what passed this year during this legislative session. Senate Bill 579, which was sponsored by Senator Schaaf initially. You'll see that we had a lot of major proposals go through the Senate side this year. Also, Senate Bill 875, sponsored by Senator Schaefer. Senate Bill 865, sponsored by Senator Sater, who is a pharmacist, as many of you may know, and House Bill 1568, which was sponsored primarily by Representative Lynch, or originally. All of the legislation that we are going to discuss today takes effect on August 28th. That is on Sunday. So as of 12:01 Sunday morning, this legislation is effective, and Missouri licensees would be required to comply. Let's start with Senate Bill 579, which I believe we've already had a significant amount of questions come in about. And this is the bill that included a variety of things. But the major thing that you need to know about today is that it includes language on telehealth and telemedicine. For years, the board has received questions on telehealth, telemedicine examinations and prescriptions that are issued after a telemed exam. In the past, we didn't have very clear language, and so some of you may have gotten frustrating answers from the board because we really couldn't answer the question simply because Missouri law didn't address telehealth, telemedicine very specifically, and of course doctors are regulated by the Board of Healing Arts. Well, as practice models begin to change and we see a real expansion of telehealth and telemedicine in almost every practice setting, I understand that the physician community asked and drafted language that would address telehealth and telemedicine in Missouri. Essentially, Senate Bill 579 allows Missouri healthcare providers to provide telehealth or telemedicine services. It contains requirements for prescriptions issued after a telehealth or telemed exam. For purposes of this webinar and also the board's newsletter, I'm just going to call it telemedicine, but recognize that the statute actually uses two different terms. So this is the definition of telehealth, telemedicine. Won't read this for you, but just note it probably generally includes what we normally consider to be telehealth or telemedicine. Again, I'd invite everyone to read the definition for yourself and also in the new law, but generally telehealth, telemedicine is now officially recognized as a standard of practice in Missouri. While I won't read the definition to you, I will tell you what the definition does not include, and this is important, and we'll come back to this in just a little bit. The definition does not include prescribing based solely on an internet questionnaire or based on a telephone examination without an ongoing and previous prescriber-patient relationship. That's a mouthful, but we'll come back to that in just a moment. Significantly, Senate Bill 579 does not just relate to physicians. It says other healthcare practitioners who are, of course, authorized to prescribe. So that would include APRNs and PAs. We want to remind everybody, though, and you'll see this in a moment, they must still be acting within their licensed scope of practice, and they still have to comply with all prescribing and collaborative practice requirements. So that hasn't changed. If they needed a protocol before the bill, they will need a protocol after Senate Bill 579 passed. So the question that we are getting in the office and that many of you have called to ask, can Missouri pharmacies fill a telemedicine prescription? Apologize for the typo there. The answer now is yes. And I wish that that was the end of the question answer, but there is always an if. And the statute has very specific requirements. First, the services must be within the prescriber's scope of practice. They also must be, number two, within the same standard of care as services provided in person. I'll talk about this in a moment. cannot be based on an internet questionnaire, and it cannot be based on a telephone examination without a previously established and ongoing physician-patient relationship. And when I say it, I mean the actual prescription itself. So what does that mean? Because I think many of you have read the statute, and we've had calls. People have looked at Senate Bill 579, and they are probably more confused now than before the bill passed. Well, unfortunately, we can't give very good and clear information here, and that's for a lot of reasons. First of all, we met with the Board of Healing Arts, and when I say me, I mean representatives from the Board of Pharmacy, and we talked with the Board of Healing Arts about telehealth, telemedicine, and we understood how difficult and how broad of a concept this may be. One of the things that we heard from the doctors was that telehealth, telemedicine looks different in every practice setting. So, for example, if you're a dermatologist, that telehealth, telemed exam and appropriateness may be completely different from a neurosurgeon, and that may be completely different for a podiatrist. So we understood that that was a very broad term, and that it was very hard to pin down what is a qualifying telehealth or telemedicine exam. I don't think this is any different from where we are now. Right now, pharmacists have a corresponding responsibility to make sure that a prescription was issued for a legitimate medical practice in the usual course of professional practice. A legitimate medical purpose in the usual course of professional practice. That is an amorphous standard, and we have never been able to give specific checklists or guidelines for how do you determine corresponding responsibility. I think that the new telehealth law, fortunately or unfortunately, still leaves part of that question open as to what actually is a qualifying telehealth exam. So we cannot give a full answer to what is a valid telehealth prescription. However, we can give some guidelines, and this is what we'd like to do today. Number one, you must have a Missouri licensed prescriber. Number two, there has to be a valid physician-patient relationship. That requirement still hasn't changed under the law. The prescription still has to comply with all state and federal requirements. So the two-line prescription format and all those other things that may apply, those are still applicable. And it must be within the prescriber's scope of practice, which is something that pharmacists probably are looking at right now. And finally, 5, it must meet the applicable standard of care. And I think this number 5 is probably the hardest determinant, if you will, trying to determine what is the applicable standard of care. The Board of Pharmacy asked the Board of Healing Arts, are you going to give more information or more guidance on what is the applicable standard of care? What I understand, again, from the Board of Healing Arts is that that question is so broad because of all of the practice settings. And that can also change depending on the disease state, the condition presented, the patient themselves. I understand that that is a very difficult task for them. So to be honest, I don't know that our licensees will see any additional information relatively soon on what is the applicable standard of care. What I think pharmacists have to do is use their professional judgment here. I'll talk about that in just a minute. One of the things you do know for sure, though, is you cannot fill if the prescription was based solely on an internet questionnaire. So if they went online, they filled out an internet questionnaire, they were emailed a prescription, that wasn't legal before the bill, and it's not going to be legal after the passage of Senate Bill 579. Can't be based on a telephone examination unless there's a previously established and ongoing physician or prescriber-patient relationship. Now, we've had some questions about this already. You know, what happens when a patient calls their doctor, their child has a recurring ear infection, they call the doctor, they talk, with the doctor over the phone, and they call in a prescription. Again, if the patient has a previously established an ongoing relationship with the prescriber, then a telephone examination is valid. So not all telephone exams are bad. If they did a telephone examination only without any other pre-existing relationship between the patient and the prescriber, we believe Senate Bill 579 says the telehealth or telemed exam is not valid. We have been asked about helplines or nursing lines where there's an 800 number, you call in, you speak with someone who you may have never met before, and that nurse, and could be actually in another state, that nurse then sends a script to the pharmacy. We are understanding from the Board of Healing Arts that if there isn't an established and ongoing relationship with the prescriber, the telehealth telemed prescription cannot be filled. And of course, you can't fill it if there isn't a legitimate practitioner-patient relationship. That is current law, and again, it remains the same law. Do you still need a physical examination? And many of you may remember that the board's previous rule said that you could not fill a prescription unless there was a valid physical examination. In anticipation of the telehealth changes, last year, I believe, the board did an emergency rule to amend, actually that was this year, the board did an emergency rule to amend our rule to say that a prescription must have been written, if after a medical evaluation of the patient as required by law. Sorry for the confusion there. In other words, prescriber must have performed a valid medical examination. That was changed by the board to accommodate what we anticipated happening with Senate Bill 579, specifically Missouri law changing. If a prescription complies with the new law, it can be filled. What about controlled substances? We've actually reached out to BNDD and DEA on this, and I would suggest that everyone go to the board's August newsletter. There's a statement in there that we received from BNDD on telehealth, telemed prescriptions for controlled substances. And so we'd ask everyone to go there. Also, the Ryan-Haight Act, the federal Ryan-Haight Act, has some federal requirements for controlled substances that are issued after an internet exam or a telehealth, telemedicine exam. We'd also ask you to go there and look at the Ryan-Haight Act. We would ask that, and we would suggest that all questions about controls and telehealth, telemed exams go to BNDD and DEA. As you will see, the idea that there must always be a physical examination may be in flux right now, so we would suggest that licensees consult with them on controls. What about out-of-state prescribers? Because I know this may be a large amount of prescriptions that are being seen right now. We have asked the Board of Healing Arts about this. We anticipate that they will, in fact, issue some additional guidance. I will ask you, or I would suggest that you talk to your legal counsel about the applicability of Senate Bill 579 to out-of-state prescribers. The bill in several places uses the term a Missouri licensed prescriber, and I think that it may be determinative for some of the provisions of the bill, but again, we are waiting for more guidance from the Board of Healing Arts, and we would suggest you take Senate Bill 579 to your legal counsel and say, how does this apply? I do want to remind everyone, though, that 2.020 still has the same caution. You can't fill a prescription if it's not based on a valid patient-physician or practitioner relationship. So even as you're looking at out-of-state prescribers, make sure, number one, that you're operating in good faith, and number two, that you are taking some steps to make sure this is a valid examination. Again, we anticipate the Board of Healing Arts providing some additional information on that. Again, we won't be able to provide all of the answers on telehealth, telemedicine, prescribing. The good news is that now these can be filled. The perhaps not so good news or concerning news is that we really can't give, again, a full checklist, but I think we do have some guidelines for pharmacies going forward. I'd like to turn our attention now to Senate Bill 875, interchangeable biosimilars. This is something that has been in the works for years, and I believe the proposal was actually written by industry in collaboration with several pharmacy association-related groups. But now, it officially, as you guys may know, Missouri has had, as most states, a law on the books that allowed generic substitution of drugs. However, our law, Missouri law, didn't address substitution of interchangeable biological products. Senate Bill 875 corrected that and essentially inserted interchangeable biological products in many of the places in our law now that references generic substitution. So you can now substitute an interchangeable biological product as referenced in the bill. If you make a substitution, there are three main requirements. First, you must inform the patient that you have substituted an interchangeable biological product. That can be done verbally or in writing. You also have to notify the prescriber of what you dispense as well as the name of the manufacturer. Again, that can be done either electronically, verbally, or in writing. The board recommends that you document that notification in your records just in case there are questions on inspection. You are not authorized to substitute if, you don't need to give notification if there is no FDA-approved interchangeable product on the market, or if you're dispensing a refill and you haven't made any changes from the prior fill. So please remember there are notification requirements. I can tell you that in the future the board may do a rule on this to provide additional parameters on documenting notifications, but as of right now, again, this statute is self-executing. It is effective as of 8/28. If you're dispensing, please make sure you're looking at the requirements of 875. Of course, substitution must comply with all other board rules that are applicable to generic substitutions, including labeling and record-keeping requirements. Senate Bill 875, it has just a one provision that relates to mandatory reporting. Hopefully this will not relate to anyone on this call, but it does require mandatory reporting of certain disciplinary and adverse actions. If you've had final adverse action taken by another licensing state or another governmental agency, that must now be reported to the board. I will note that that is final adverse action. So if there's a complaint pending, that's not what needs to be reported. We are asking that you report, or the statute requires that you report after that action becomes final. Voluntary surrender while under disciplinary investigation. So if there's a complaint filed, another state board is opened up an investigation, and you choose to voluntarily surrender either your pharmacist license, your pharmacy license, a drug distributor license, that now needs to be reported to the board. If you're excluded from any state or federally funded health care program, Medicare, Medicaid, in any state, that also has to be reported to the board as well. The board anticipates doing rules to actually spell out the reporting requirements right now. The board is asking that licensees report within 7 days. We have an online form that should be up and running by Sunday, August 28th. Again, hopefully no one will need to use it, but we hope to have an online form available for you. There is a space on the board's website, a button that says online services and reporting. If you go there, you should be able to link through and file an electronic report. Consolidating refills. This was also contained in Senate Bill 875. The newsletter in the board's website has a link to all of the legislation, so if you want to look at this on your own, please go to the board's website again. This is probably the one area where we've gotten the second highest number of questions outside of telehealth and telemedicine. So let's just walk through generally what Senate Bill 875 now says. It enacted Section 338-202, which allows a pharmacist to consolidate refills of maintenance medication in a single fill. So if a prescription is written for refills, you can now consolidate those and dispense all at one time. Maintenance medication is defined as a medication that has been prescribed for a chronic long-term condition that is taken on a regular recurring basis. The statute doesn't define what a chronic long-term condition is, and so again, pharmacists are going to need to use your professional judgment, but you're probably talking about, your general ones: heart disease, high blood pressure, high cholesterol, diabetes, kidney diseases. If you believe it meets the definition of a chronic long-term condition and that has been taken on a regular recurring basis, it qualifies as a maintenance medication. Statute says that pharmacists can dispense up to the total number of authorized dosage units, so what the prescriber wrote for. However, you're limited to a 90-day supply. You cannot dispense more than a 90-day supply at one time. The statute does say that the patient must have previously been prescribed the maintenance medication for at least a 3-month period. So let's say we meet the definition of a maintenance med. The patient must have been prescribed the medication for at least a 3-month period. And we've gotten a lot of questions on this. We've had licensees call and ask, Does that mean 3 consecutive months? Can that be spread out over a year? The statute doesn't give any guidance here. The statute just says for at least a 3-month period. So the board actually looked at this on the most recent conference call, and the board is asking pharmacists to use their professional judgment. If you can document that the patient has been prescribed the medication for any 3-month period, I think that it's subject to or allowed under the statute. It doesn't have to be the immediate consecutive months prior to your filling the prescription. Again, just a 3-month period. The other question that we've gotten is, does this mean that I have to fill the prior the medication for that 3-month window? So I'm at Pharmacy A, and a patient has been on a maintenance med for 3 months, but it was filled at Pharmacy B in another city. Can I then look at what they've been prescribed there or their dispensing history there to qualify for the 3-month period? Again, the statute doesn't give specific information on this. So right now, without further guidance or anything else in the rule, it appears yes. You don't need to be the pharmacy that filled the prior maintenance meds. As long as you can document that the patient was on the meds again for a 3-month period, we believe that it's subject to the consolidating refills allowance under the statute. The board recommends, it's not required right now, that you do something to document the patient's eligibility. If you didn't fill the prior scripts, it might be a good idea, probably a good practice, just to document why you consolidated refills and that you had a patient that fell under this window. The board may be doing additional rules on this at some point. The board hasn't given final approval of that or said if they would, but this may be one of those issues that may be addressed later on in a rule. But for now, the statute is effective, and again, pharmacists should be using your professional judgment to make sure you have someone who is authorized, that you are authorized to consolidate for. You, of course, cannot consolidate if the prescriber has indicated on the prescription that consolidation is not approved, or the way the statute actually reads is if the prescriber says that dispensing the initial amount followed by periodic refills is medically necessary. Now that's the exact language from the statute. I think to be safe, if the prescriber indicates on the prescription not to consolidate refills, then I would suggest not consolidating them in any manner. Controlled substances cannot be consolidated. This is an important point, so this does not apply to controlled. We are talking about non-controlled only. Again, pharmacists should exercise a professional judgment. Consolidation may not be appropriate for all patients. There may be some patients who, consolidation may not be a good idea for. I'll give a good example. My mom had an illness last year, and at some point she was very confused about all of the medication that she was taking, and it may not have been a good idea to consolidate for her because she may have gotten confused. If you have a patient you don't believe that consolidation is good for them, then again, use your professional judgment. Significantly, pharmacists aren't required to consolidate. This is a discretionary sort of option for pharmacies. But again, you should be looking at your patient. What are you dispensing, and is this a good idea? Also, the board suggests, this is not required, but the board suggests if there are additional costs or insurance requirements for patients, you may want to also advise patients that there is an additional cost for the consolidation. I know many times we've heard from pharmacies that the copay is the same. In those cases, there may not be an additional cost, or the copay goes from $4 to $6. If you will. But if there is a significant cost, it may be something that the board suggests that you at least let patients know that this is not mandatory and that they may have the option to dispense as written. Okay. And again, we'll take questions in a moment if any come in. And I know we're moving through these very quickly, but I want to make sure we get to everything. I think the final piece of legislation that I wanted to discuss on the call today is House Bill 1568, which relates to naloxone dispensing. Actually, the bill uses the term emergency opioid antagonist, but it's defined as naloxone. So we'll just use that term for reference here. House Bill 1568 now authorizes Missouri pharmacists to sell and dispense naloxone without a prescription if you have a protocol with an authorizing physician. And so I want to make that clear. I think there may be some misunderstanding. We've had questions. Does this mean that every pharmacist can dispense naloxone? Every pharmacist can if they have a protocol with an authorizing physician. No additional board license or certification is required. This is not like immunization where you have to follow notification of intent and also have a protocol. If you have a protocol right now, you don't need to notify the board and you are authorized to dispense naloxone. Significantly, the board doesn't include, the bill, doesn't include any purchase restrictions, so there are no limits on age, quantity, relationship. I know in some states naloxone can only be dispensed to family members or caregivers of someone who's at risk of an opioid overdose. The Missouri legislation did not include that language. Again, pharmacists should be operating in good faith and using their professional judgment. You may be restricted, however, in the protocol, and this is something that I'll repeat a little bit later. Your protocol could always be stricter than what Missouri law requires, and that is true really for MTS, for immunization, but in this instance, if the physician imposes or requires additional elements for dispensing naloxone, the board would anticipate that pharmacists would comply with what's in the protocol. Speaking of protocol, and we've had questions come into the board on this already, there are no specific protocol requirements. The statute just says a protocol. Right now, the board hasn't done a rule on this, and again, the board is in discussions. I don't know if the board will, but Missouri law doesn't include specific protocol requirements. Again, pharmacists should be talking to their physicians and coming up with a protocol that really works for you. To assist pharmacists, however, the board asked that we draft a sample protocol, and there is a sample protocol, and I'll show it to you in just a moment, that is currently available on the board's website. So if you need assistance on maybe just getting a protocol form or a protocol draft, there is a sample on the board's website. Everything in the sample protocol is just that. It's not really suggested template, really. It's more of an example of how a protocol could be structured. We would ask pharmacists and physicians should be going through that protocol. There may be some things that you believe are unnecessary in that sample protocol, or things that you think are not required or maybe burdensome. Please go through the protocol and select what you believe is appropriate. And again, the protocol can always be stricter than the statute. The board recommends that you document all sales, all dispensing. Should you be dispensing by prescription, of course that should be documented in your prescription record. If you're selling naloxone, significantly, the statute allows you to sell to a person or an entity. The board recommends that you document the sale. Actually, our law requires that you document the sale. The board recommends that you document the transaction date, what you sold, the quantity, and if you know the names of the parties and entities. Now, again, this is not required. This is just a suggestion on what you should be documenting in the pharmacy's records. I want to remind you about Missouri law for first responder agencies. In 2014, Missouri passed a statute that allowed pharmacies to sell to first responder agencies without a protocol. The statute is section 190.255. This is in the August newsletter as well. So if you want to look at this for more information, it's also in the current Missouri Pharmacist practice guide. But if you're selling to a first responder agency, you don't need a protocol for that. House Bill 1568 does not change that. So if you're dispensing, or if you have been dispensing to a first responder agency, you can continue to do so without a valid protocol. To assist pharmacists and patients, we have set up a naloxone resource center on the board's website, and you'll see the website address there. There are several things in that naloxone resource center that we think would be helpful for pharmacists. First, there is a naloxone FAQ or guidance document that is just for pharmacists. It will summarize a lot of the information that I provided today. So if you have questions about naloxone dispensing, or you want to educate your staff at your pharmacy, go to the Resource Center and you'll see the FAQ there. The sample protocol is there as well. And again, that can be downloaded, changed, and altered as may be appropriate for your practice setting. We've also done a patient brochure, and one of the things that, of course, everyone knows is that the mission of the board is to protect the public, and that includes patients, of course. And so we've done a patient brochure that pharmacies can use to give to patients to explain to them just a little bit about what naloxone is and to give more information about opioid abuse. We'll look at it in just a moment. Actually, we might as well go through now. This is an example for those of you who have not gone to the website yet, or if you click on the link, this is just an example of the board's resource page. You will see many of the things I talked about today and other information for patients. One of the things that I want to note for patients is there's a lot of information there. There's a document on Missouri opioid safety, overdose, resuscitation, what you should do after giving naloxone and suggested steps. There are documents from SAMHSA, also the Department of Mental Health, and also resources they can have. So if you have someone who's at risk, or if you have someone in the pharmacy, you may not be able to give them a full range of information over the counter, but on the website, we do have information. All of the information on the board's website can be printed. And of course, there's also additional information for pharmacists. If there's a document called 5 Essential Steps for First Responders, again, it has a lot of good information for licensees. There's also an opioid overdose prevention toolkit, and that's put out by SAMHSA. It is a full toolkit that can be downloaded and printed. It has a lot of information for pharmacies, for patients, for families, and things that you can give out. We suggest that licensees go to the board's website. This is an example of the patient safety brochure that is online now, and we tried to write this brochure. It's shown here in brochure format. This is page 2 of the brochure, but we tried to write the brochure in readable and readable language that would be good for patients. It gives information about types of opioids. When we say opioids, there are a lot of patients who may not know what an opioid is. And I'll be flipping back and forth just so that you can see this. We answer the question, what are opioids? What is naloxone? How to avoid an opioid overdose? And again, a lot of this information came from other state and federal agencies. Who is at risk of overdosing? A lot of times when we say overdosing, a lot of patients think heroin users, and of course we know they're at risk. And we know, and you've seen this in the news, that heroin use has been increasing statewide. But there are other people who are at risk of an opioid overdose. People who are new to using opioids, people who are using opioids against their doctor's advice or without doctor's supervision. We wanted to note that as well. Signs of an overdose. We, of course, encourage them to contact 911, but there's also resource information if they need to go into treatment. We understand that a wide population of patients may come into pharmacies and seek to buy naloxone, so we wanted to give that information. We have a website where they can go look up treatment programs. The Missouri Suicide Hotline is also available there, and then again, other state and federal websites that they can use to find additional information. Now, the board did approve providing this patient safety brochure to pharmacies for free. So if you would like a limited number of copies of the patient brochure just to keep at your pharmacy, please email the board office at missouribop@pr.mo.gov. If you go to the website, if you didn't catch that, our website is there. Email the board, and we will send a limited number of patient safety brochures to you for free. They are actually printing now, so we should have those available by early of next week. If we can't do large numbers, we can't do 500, but if you let us know what pharmacy you're in, how many you need, we'll make sure that we send those out to you, because again, we think this is a really important patient safety protection measure, and we'd love to make these available for Missouri licensees. This is a copy of the sample protocol that I talked about earlier. It is a PDF document online. It's not very long. It's actually a 2-page document for those who are interested in the document. Again, you can modify this if you'd like. Some of these provisions, when you read them, you may think, well, this just doesn't work for my practice setting. Then we suggest removing them. But if you need an example of a protocol template, there is one online. So the board anticipates providing additional information and doing some additional education on the new legislation, but everything, of course, is available on the board's website. If you have any questions, feel free to call your inspector, or you can always email us at compliance@pr.mo.gov. Having said that, that is the close of our legislative update. I'm going to turn the next portion of the webinar back over to Tom. He's going to go, since we're moving just a little bit early, he's going to go over some of the 2015 inspection violations. What we did with the 2015 inspection violations is we went back and we looked at things that were noted in inspection reports during the fiscal year of 2015. We summarized those and grouped those together, and Tom's just going to give you some information about what we found. I think it's going to be a very good summary. So as you're looking at your pharmacy, as you're looking at your practice, you know some things that you should watch for as you're looking at compliance. In the interim, I'm going to look at questions. We probably will come back within the next 10 minutes or so and try to address some of the questions you have on the legislative implementation. Having said that, Tom.
Thank you, Kim. As Kim said, we did kind of summarize what we found in fiscal year 2015, and here's a pie chart of what how we broke it down. And some things, it's not 100% accurate, the title for what the issue was, but we did the best we could in grouping it into common groups here. And as you can see, two of them make up almost 50% of the violations noted on inspections dealing with immunizations, administrations, and controlled substances. So that makes up almost 50% of violations noted on inspections. And then the others, you can see here, breakdown. And what I'm going to do today is I'm going to go through each group, and I'll give you the top three that we found. So for administration and immunization, our top three were, first one dealing with notifications. These are either missing, late, or incomplete, or unable to produce them. Protocol issues, this would be like a protocol missing, unavailable, not signed, didn't have one, not dated. And then administration prescription is incomplete. That would be an example of that would be the prescription didn't have the statement for pharmacists to administer on it. For controlled substance, our number one violation was dealing with annual inventory issues. Probably my guess was majority of these would have been taken late. They were over a year old. Some of them could have been just missing groups of drugs or what was documented on it. Prescription violations, this encompasses a lot of different kind of violations, but just incomplete prescriptions, unsigned prescriptions that weren't authorized, and then electronic prescriptions that had been converted to fax by the time the pharmacy received them. Improper security was our third group. An example of this, probably the most common one, would be the C2 cabinet was unlocked during the time of the inspection. For general compounding, compounding log being incomplete or inaccurate was the number one item. Number two is beyond use date greater than ingredients expiration date. This is surprising how often we find this, that when the pharmacist reviews the log, they don't catch that one of the ingredients listed there is going to expire before the beyond use date of the preparation. And then compounding commercially available products was the third. For dispensing, our number one issue noted was dispensing error. This is when an inspector reviews a prescription and compares to what the pharmacy has in their record, and it appears that an error occurred either in labeling or the drug that was dispensed, or maybe the strength of drug dispensed. Labeling errors was number two, and I believe this also, labeling errors was only prescriptions, but also maybe a drug stock in the inventory also. And then number three was failure to verify the source of a prescription on photocopies or faxes. It was unclear where it actually came from. Pharmacy conditions, it includes a wide variety of issues. Improper drug storage would be the number one. This would be such things as improper temperature, proper storage container, no lid on a storage container. Unsanitary conditions was number 2. A lot of this time, this is usually around the sink or the reconstitute tube, probably other number 2, most 2 things noted. Sometimes it's just overall conditions are unsanitary at the pharmacy. Permit issues was number 3. That's usually dealing with the wrong class on the license. And there was a tie for number 3, improper refrigeration and temperature controls was number 3 also. Record keeping, again, a wide variety of records are included in a pharmacy. In the top 3 here, 2 of them deal with policies and procedures. First one is missing or incomplete. Second was prescription records were incomplete, inaccurate, or missing. And then again, number 3 was policies and procedures were not available. So policies and procedures make up a large percentage of record keeping violations. For sterile compounding, and keep in mind this data is before the emergency rule went into effect. This is on the old rule, but cleaning and unsanitary conditions were the top issues. Failure to conduct or document your annual aseptic technique validation, that'd be media fills, was number 2. And then again, policies and procedures come in here again. They were missing or in sterile compounding requirements are annually reviewing them. So policies and procedures, again, an issue. So I kind of went through those very quickly so we have time for questions. I believe we will be posting some of this eventually on our website, and we plan to in the future each year do a summary of what the top issues were. So we're now going to switch over to questions. If you want to send us a question, go ahead and type it in on your GoToWebinar toolbar, and we can and hit send, and we'll get it.
Okay, so I'm going to go through some of the questions, and many of them are similar. One of the questions that someone asked was, how do you know, how do you recognize a telemedicine or telehealth prescription? How do you know that it comes from a telemedication conference? To be honest, in many of the instances, you may not know. You may not know. Interestingly, the law doesn't place on pharmacists a requirement to determine if the prescription was written based on a telemedicine examination. The law only addresses what happens or what can be filled if you do know. So again, I understand that there may be signs that show that a script is based on a telemedicine examination. For example, especially on the St. Louis side, you may know that this is a certain hospital and or a certain physician's office has set up a telemed program. We've heard that there are some prescriptions that will identify telehealth or telemedicine on the prescription because it's part of maybe the logo or something like that. The other thing is there may be other cues that may suggest a telehealth or telemed exam. For example, distance. If someone has a script that was called in this morning and they have the Kansas City address for the prescriber and the patient is submitting the prescription in St. Louis, it may raise some questions as to how that prescription, the patient was seen. Again, this is part of, and I know that this is probably going to be the confusing thing for pharmacists. The law really isn't clear here. You're not required to determine if it is a telemedicine prescription, but if you determine that it is, then the law does require some additional requirements, if you will. How do you know if the telemed script was based solely on an internet questionnaire? I think the best answer to that question is I'd ask. If you have a telemedicine prescription, you can tell, or for some reason, you know that this is a telehealth, telemed script. I think that you should be asking, how were you seeing? Did you go online? Was this an electronic connection? You should be talking to the patient at that stage. How do you know if there is a previously established relationship with the patient? And some of you, during the slides, we talked about telephone examinations and how the law now says that if you do a telephone examination, you cannot fill a telehealth telemed script unless there was an established an ongoing patient-prescriber relationship. So how do you know? Again, I think it would be just ask. If you know you have a telehealth, if someone says, I called my doctor and they called this in today, you may want to ask, are you a new patient? Have you ever been seen by the physician? You may want to call the doctor's office. This statute will complicate. It will help pharmacy to the extent that it does answer the question. The idea that you just simply cannot fill a telehealth telemed script, that's no longer the case. We do know that internet questionnaires are still banned. You cannot do that. That's prohibited. But it will not answer all questions. And again, I think pharmacists are in the position they are now with corresponding responsibility, right? Because right now you're required, you cannot fill a prescription if it wasn't issued for a legitimate medical purpose and the usual scope of professional practice, and if there isn't a legitimate patient-prescriber relationship. So some of the questions haven't changed. Some of these questions you should be asking now. The problem is, and I do understand, that there really aren't clear guidelines. So I think the biggest answer here would be operate in good faith. Of course, the board looks at these issues. If the board goes in, if an inspector goes in, we see a prescription that on its face you may have never known that it was a telehealth, telemedicine examination. I personally don't see the board going back to ask you about something that a reasonable pharmacist would not have known standing at the pharmacy counter. But if there are signs that show that this is a telehealth, telemed examination, you know to ask the next question. And that's what I would suggest that pharmacists do. Look for signs to ask the next question. Someone has asked again, does a telehealth visit establish a physician-patient relationship? The answer is it could. If it complies with the statute, the answer is yes. If there is a valid telehealth, telemed examination that complies with the statute, it's within the standard of care, it's within the scope of practice, and those things, yes, it can establish a valid physician-patient relationship, which is one of the things that the law was specifically trying to address. I want to make sure I do all the telehealth questions, or as many as I can, while I'm here. Alrighty, I have some questions on consolidating refills. On consolidating refills, someone has asked, well, no, let's do interchangeable biosimilars first. Someone has asked if the statute still requires that the product must cost less or equal what the original product or the brand product. That is still the case. Senate Bill, legislation still includes that language. The same language that applies to generics would apply to interchangeable biologics. Give me just a moment. If the provider writes the prescription for 90 days, can the prescription be filled for 90 days?
The answer would be yes. There wouldn't be any consolidation or refills needed if it was already written for 90. Keep in mind, this 90 days is not a day supply limit on prescriptions in general. It is only if you're consolidating refills. So don't take this as there's now a 90-day supply limit on prescriptions. I think we had a question about if a doctor writes 100, can I fill it for 100? Well, yes, the doctor wrote for 100, assuming it's not a controlled substance limits aren't applying, but this is not a 90-day supply limit. It's only when it comes to supplying consolidating refills. And we have another question on, can we dispense more than a 90-day supply for someone like going on a vacation? The answer is you cannot consolidate refills for greater than a 90-day supply, but you could call the prescriber and get authorization for a new prescription for a larger than 90-day supply. But keep in mind there are controlled substance supply limits that would also apply to any prescription.
I have a question on naloxone dispensing. Someone asked, can a pharmacist administer naloxone to a patient if an overdose happens at a pharmacy? We knew this question was going to come in. The statute, when they were working through the bill at the legislature, the statute originally included some language on pharmacists administering naloxone at the pharmacy. As the bill was passed, that language was taken out, and it only talks about pharmacy dispensing or selling. However, and this is a significant however, the bill otherwise says that any person can possess and dispense naloxone. So, which would be any citizen or any patient walking down the street. So, when we had some discussion about this in-house, I think absent further guidance, and again, can't give legal advice, but absent further guidance, if a citizen could do it, an unlicensed person could administer naloxone, then I believe that a pharmacist could administer naloxone as well at the pharmacy to someone in active overdose, maybe not as a pharmacist, but just as a private citizen with someone as someone in possession of naloxone. So I think the board would say do what's in the best interest of the patients, and again, the statute does say that any citizen can possess and administer naloxone, and there's actually a liability provision. I didn't go through that while I was walking through the bill, but the bill does contain some liability exemptions for pharmacists and people who administer naloxone in the event of an overdose. Give me just a second.
Someone is asking about compounding kits, such as the first kits, and wanting to know, are those considered commercially available? The answer is no. If you look in our practice guide, we have a section about compounding kits. It is considered compounding. You need to fill out a log, but just because there's a kit available doesn't mean that that product is commercially available. Now, that does not apply. Some, like the kits like Benzaclens and stuff like that, those would be commercially available, but just a kit of the ingredients to do a compound is not considered commercially available. Someone's asking for telemedicine, can a prescriber prescribe lifestyle drugs such as Viagra? Was an example they gave. The statute doesn't prohibit that. They would need to fall under all the other statute requirements in order to do that, though.
Someone's asking, if you substitute an interchangeable biological product, do you have to inform the prescriber first? The statute does not require pre-notification. It does require, though, post-notification. Someone's asking, in regards to reporting to the board within 7 days of discipline, does this mean any sort of discipline against an individual pharmacist license? Yes, any sort of discipline. So that would include public censures, that would include probation, suspensions, and different states have different things, fines that may be imposed. Again, the statute says final adverse action. Our board has some non-disciplinary resolution tools like letters of concern, letters of warning. I wouldn't include those in the list of mandatory reporting elements, but if you have official discipline, something that is final and something that is public also, I think that needs to be reported to the board.
And you don't need to report past discipline. It's what takes effect. Anything after August 28th is what you have to report. So if you had discipline 3 years ago in another state, you're not required to report that under this provision.
Good point, Tom. Good point. And it's only going forward. So please do not send us notifications for all the previous years, just going forward. You may also want to share this with your staff because this applies also to technicians, interns, pharmacies, drug distributors, drug outsourcers, even though we don't have that separate class in the state of Missouri, the statute does specifically reference them. So if it's a license that relates to the practice of pharmacy, you should be notifying the board online or in writing. So I think someone's asking if this webinar is being recorded. It is, and it should be posted to the board's website within a few days. It looks like we've gotten to most of the questions. A few of them, again, many of them asked the same question. Hopefully we were able to do that. If we didn't and you still have questions, please email the board at compliance@pr.mo.gov. Actually, if you use any of the board's email addresses, we'll make sure it gets to the right person. Also, to talk with your inspector. and visit the board's website. The August newsletter, the naloxone FAQ guidance, all of that is on the board's website right now. Well, it's 12:59. We want to thank everyone for participating. Tom will tell you how you get CE.
Before I do that, our next Lunch with the Chief webinar will be on Tuesday, October 25th. Watch for email alerts for registration and notices. After I close the webinar, you will get, don't close your browser until you get a little window that pops up saying the webinar has ended. At that point, click close and a little survey will open up. Answer the questions on the survey and submit them. We have reports that some smartphones and tablets may not receive the survey. If you have any issue in receiving the survey and you don't get the questions, you can email compliance@pr.mo.gov and ask for them, and we will email them to you. You must get those back to us within 48 hours to be considered for CE. We will mail certificates in approximately the next 30 days. And again, there will be a link of this recording on the board's website. So I am now going to close the webinar.